Okay, there you go. That's the first time I've heard that with an echo, the recording progress. Good afternoon, everyone. And first of all, particularly with the elements, I really want to convey my gratitude and my appreciation and thanks for all of you being here. My name is Professor Saeed Khan. I teach in the Near East and Asian Studies Department and the Global Studies Department. And I'm also the director of Wayne State's Center for the Study of Citizenship, founded in 2001 by Professor Emeritus of History Mark Crewman. The center is really the premier global institution exploring the various complexities and contexts of citizenship. And I thought that today's topic perhaps is a wonderful way to begin the semester and hopefully turn this into a series throughout the term. I have a feeling this is probably not the only foreign policy issue that requires a deep dive of exploration, and particularly with the blessing that we have here at Wayne State of a really august group of scholars that we can draw from without having to invite them from other institutions, whether down I-96, I-94, I-75, or the interstate highway of your choice. We can keep it in-house, and we can then go ahead and highlight the expertise that we have on a myriad topics, starting today, of course, with Venezuela. We are going to be joined by my two esteemed colleagues here, Professor Brad Roth, professor in political science and at the law school, and Professor Gregory Fox at the law school, respectively. Probably what we will do is go about 15 to 20 minutes each in our presentations, and then really open it up to you with any questions that you have, and hopefully keep it as interactive as possible. The idea for this came about really as soon as the news cycle broke on January the 3rd of this year with the U.S. Invasion of Caracas, Venezuela, the capture and absconding of President Nicolas Maduro and his wife, Celia Flores, and them being brought back to the United States, where they then face charges in the Southern District of New York on narcoterrorism and conspiracy to import cocaine into the United States, along with some other weapons charges as well. As some of you may have been following this in the news cycle, you might have questions that doubtless have come to the fore, either because those questions have gone unanswered, or perhaps there has been a deficit in the way that these have been answered. Today's presentation is going to be a sliver of a rather complex issue. We're going to be focusing on the legal dimensions, both U.S. and international law, with our esteemed colleagues. I know that there are other events. I know that Professor Roth will describe those, which will also be ancillary in looking at other aspects of the conflict regarding Venezuela. So with that, again, welcome, especially to my students that are here. Thank you very much. I know it's the first week of the semester, and that's one of the reasons why I thought perhaps this will work out well, that your first midterms are probably not until Friday. That's just a joke. So you can then go ahead and be part of this now. So if you'll beg my indulgence, I will go up to provide you with a brief timeline of what has been going on. And of course, as a historian, a timeline is something that's not necessarily confined to the last few months. We have to go back in the TARDIS, so to speak. And so I thought if there is a point, and I was speaking to Professor Roth about when to really begin, and there are so many different on-ramps that we could have, but I decided to use the ascension of Carlos Andrés Pérez as president of Venezuela in 1974. He served 2 terms of about 4 to 5 years each. But what was really significant about his ascension to the presidency, it was he who nationalizes the oil industry in Venezuela. And this is, of course, a very pivotal issue when it comes to, of course, the narrative, or should I say, one of the narratives regarding Venezuela that we hear today. And I know it has been a bit confusing because at one point it was about the fentanyl, and then it became about cocaine, and then it became about human rights. And now it seems as though it's oil, or maybe it is not. And maybe it is, like your favorite multiple choice exam, all of the above. So I guess that remains to be seen by what then comes from the White House, the Pentagon, or the State Department. Under Perez, we have the establishment of PDVSA, or the Petróleos de Venezuela S.A., which is the state's oil and gas company. And as I'm sure Professor Roth and Professor Fox will explain to you, nationalizing an oil industry is perfectly legal under international law, provided, of course, fair market value is paid for the assets. We could have an entire conversation, of course, about the 1951 nationalization of the Iranian oil sector by Mohammad Mossadegh, but maybe that is sauce for another panel discussion that we have. I see a colleague of mine here who's nodding, and maybe I can entice her to be involved in it. Eclipses don't work in the auditorium, Layla. But the idea then that perhaps the seeds were sown 50 years ago with the fact that Venezuela took an action that it could. Of course, this meant disenfranchising international oil companies, including, of course, American ones. Moving forward, I thought it also important to recognize the Chavez years of Hugo Chavez, who was president from 1999 to 2013. And here we find that his use of state funds that were generated from the nationalization of oil helped to transform Venezuela, and in many ways also the region. Chavez, although certainly somebody who received quite a bit of opprobrium here in the United States, was quite pivotal in leveraging the national asset to subsidize fuel throughout Latin America. Many countries became heavily dependent on the import of Venezuelan oil, particularly as it was subsidized and heavily discounted, including Cuba and others. Chavez was then summarily branded to be a socialist and somebody who was seen to be inimical to American national interests. He seemed to survive many efforts to have him toppled. In fact, it was his own health, which then proved to be his demise with his passing in 2013 of cancer. Moving up to the more present, we have then his designated successor, Nicolas Maduro, coming to power upon Chavez's death in 2013. His tenure has seen a few different changes, more on the global oil supply that, of course, then affects Venezuela as well. A lot of oil oversupply in early 2015 that then also ran commensurate to a decline in not only Venezuela's oil production, or what is also seen as the neglect of Venezuela's oil sector when it comes to its logistics. You see that from 2014 to 2016, real GDP plunges by about 24 to 25%. And we also find that the inflation rate in Venezuela spikes. Some of this was also due to foreign intervention, including sanctions and embargoes placed on Venezuela. But as far as Maduro is concerned, he also received the I suppose, the eye of the United States with indictments in U.S. federal court 5 years ago, or now 6, on the very charges of which he has now been indicted and arraigned: narcoterrorism and conspiracy to import cocaine to the United States. Well, looking then in the more contemporary, particularly over the last year, actually, I have to take that back. It's not even been a full year. It is only January the 14th. So this is only from the last 359 days, just to be exact. Excuse me, on the day that he was inaugurated and took office, President Trump issued an executive order designating criminal organizations and drug cartels could be classified as foreign terrorist organizations, including the Tren de Aragua, which is a Venezuelan organization. But unfortunately, it seems as though there's a bit of a dissonance within the Trump administration because U.S. intelligence agencies were unsure of the president's claim that Maduro actually was working in concert with the Tren de Aragua. A month later, there was a formal designation of 8 Latin American crime organizations as FTOs, including TDA. And we find that there seems to be, at least rhetorically and in action, a bit of a lull going through the spring and through most of the summer. It is in August of 2025 that we then see a spike in military intervention when the United States deploys 3 guided missile destroyers off the coast of Venezuela and expands this to include amphibious vehicles, which are capable of dispatching up to 6,000 sailors and Marines. It's in the following month that the United States sends F-35 stealth fighter jets to Puerto Rico as then a more convenient launch point to reach Venezuela if need be, and also deploys Navy submarines with cruise missiles off the South American coast. There's, of course, as we are now familiar, a series of U.S. military attacks on boats. Their categorization and also their contents have never really been fully proven independently as to what they were containing, whether or not they were just fishing boats and trawlers, or whether they were, in fact, couriers for drugs. The first of these occurs on September the 2nd. The allegation is made that this is by the Tren de Aragua, and of course, the allegation is that Maduro is working with them. Trump claims that 11 on board were killed. Within another 13 days, there is another strike, 3 are dead, and the White House claims that there are large packages of fentanyl and cocaine strewn over the ocean, but these images have never been released to the public. And so I'm just going to go through these very quickly because you'll see, of course, that there are numerous strikes on boats. It is in October, 1 month after that initial strike, that the president declares drug cartels to be, quote, enemy combatants, and even claims that the United States is now in an armed conflict with them. The following day, Department of Defense Secretary Pete Hegseth announces the 4th strike, and 11 days later, a 5th strike. It is the day after this that the president confirms that he has authorized the CIA to conduct covert operations inside Venezuela, and that he is even, in fact, weighing the use of land operations on Venezuelan soil. It's interesting that just 2 days later, Secretary Hegseth now makes an allegation that a Colombian rebel group, the ELN, or the National Liberation Army, is also involved in this. So you see that there is an effort to try to expand the scope of what's going on. Another dimension of this is that the Pentagon uses the Venezuelan strikes to also justify attacks on boats, again, with the claim that they are running drugs in the Eastern Pacific. So this is not just confined to the Caribbean or the Southern Atlantic. October 24th of last year, Hegseth orders the largest naval vessel in the American arsenal, the attack aircraft carrier, the USS Gerald R. Ford, to the Southern Caribbean, and then takes great relish in the following days to announce more strikes occurring both within Venezuelan, off the shore of Venezuela, as well as in Eastern Pacific. It is on Halloween that the United Nations makes a public statement by way of Human Rights Chief Volker Turk, calling for an investigation into the strikes. As you see here, the month of November goes through with yet more strikes on boats, no verification for whether there were actually drugs on board or whether these individuals were in fact, quote unquote, narco-terrorists. On November the 11th, Venezuela launches a massive mobilization in reaction to the escalation of American military involvement, mobilizing its troops, bringing in volunteers for 2 days of exercises, as I said, in response to what was happening with the U.S. Starting in December, as some of you remember, there is the seizure of oil tankers in the region. There is the claim that is being made that these are sanctioned tankers and the need to then go ahead under American authority, take control of them. The first one is carrying 2 million barrels of crude oil. On the 16th of December, there is quite a bit of public clamor for Hegseth to release the tape or the video of the images regarding the September 2nd strike, because there was apparently a second strike that was conducted while there were clearly survivors on board, and they were eliminated as well. On the same day, Trump orders a total blockade of all sanctioned oil tankers going into and out of Venezuela. And as I said, the boat strikes continue unabated. December 20th, Homeland Security Secretary Kristi Noem claims that the U.S. Coast Guard and the Department of Defense has stopped a second tanker off Venezuela. And then we have 9 days later, where the president claims that the U.S. has struck a facility, quote, where boats load up. I'm not sure if there was any more technical terminology that was used, but there is also an ambiguity as to where it happens. The president does not disclose this. However, the following day, the CIA does and acknowledges that not only are they behind the strike, but it was on a docking or loading facility, and it, in fact, was on Venezuelan soil. At the end of the year, on December the 31st, the United States imposes sanctions on 4 companies that operate within the Venezuelan oil sector and designates 4 more oil tankers to be, quote, blocked property and part of a bigger shadow fleet that is seen as a threat to American national security. On the first day of the year, on January the 1st, President Maduro addresses by way of an interview on state television that Venezuela is open to negotiating an agreement with the United States to combat what had initially been the stated objective of American involvement, that is to combat drug trafficking. But as I mentioned before, 2 days after that, the U.S. conducts a quote-unquote large-scale strike across Caracas and captures Maduro and his wife. An estimated 75 to 80 people in Venezuela were killed, despite the president saying that no one was killed. Well, no American personnel were killed, but several were killed in Venezuela. 2 days later, Maduro and his wife appear in federal court in Brooklyn, New York, and are in fact read the charges on narcoterrorism and conspiracy to import cocaine to the United States. They both plead not guilty. The U.S. Attorney General Pam Bondi accuses Maduro in the proceedings and in the charges of leading, quote, a corrupt, illegitimate government that for decades has leveraged government power to protect and promote illegal activity, including drug trafficking, end quote. And that is where we are right now. What we will now do is move to understand the legal implications, the legal justifications, and the legal consequences, both from a U.S. legal perspective and an international legal perspective. And I invite for that first, Professor Greg Fox. Thank you.
Well, thank you, Saeed, and thank you, everyone, for being here to talk about this very interesting and rapidly changing set of circumstances. So my job is to talk about how the I'm actually thinking about how I should describe the U.S. action, the U.S. intervention, the U.S. invasion, the U.S. rendition. I'll probably just pick one, but it's just for ease of vocabulary because there's so many different ways you can describe this. I'm going to talk about how this plays in public international law. Brad Roth will then talk about the U.S. law aspects. There are going to be overlaps between what I say and what Brad covers. And hopefully at the end, you'll have a series of questions to ask about either or both. I think the first thing to say is that the administration has not released a clear legal justification for its actions in Venezuela. Conveniently, at least for me, at about 9 o'clock last night, the Justice Department released a memo by the Office of Legal Counsel, which is the elite office in the Justice Department that advises the executive branch on the lawfulness of prospective action, about the question of, and the answer is redacted. The OLC, advises the president on issues that, by their very nature, have not been reviewed by courts, right? Because they haven't happened yet. OLC is regarded as essentially making law for the executive branch until the issues have been reviewed by courts. So, in theory, these are quite important documents. I think it's fair to say that the answer that OLC gives to the question of whether the American actions were lawful under international law is we don't care. And I'll go through that in a little bit in more detail. But I just want to flag that what I'm going to be doing is essentially constructing arguments that somebody who in good faith wanted to justify what the administration did would make if they A, did their research, and B, were willing to go public. There are bits and pieces of all of these arguments that have appeared in public documents, and I'll try and flag those for you. But no one has made a full presentation in the way that I have, that I hope I will, excuse me, including the U.S. ambassador to the United Nations, Mike Waltz, who appeared before the Security Council, made a statement, and did not make a single legal argument about why this was a lawful action. And, you can understand doing that at a campaign rally or to a U.S. court that's only concerned with U.S. law issues. But to do it to the Security Council, the place where international law has a home, is rather remarkable. And I think that tells you where in their scheme of values international law falls. Some of these arguments may seem, a little bit esoteric to you. I hope I just do there. Okay. Some of them might involve concepts and terminology that may not be familiar. But I want to flag two things about the concepts that I'm about to review. The first is that none of them are remotely controversial. They may be a little bit difficult to assimilate, especially if you have a background only in American law. But in foreign ministries around the world, which at least in larger countries have lawyers who are well versed in these matters, these are not difficult issues. So to the extent that we find complexity, it is a complexity that only the United States and a few other countries try and put to the forefront. Where do we start? We start with this treaty provision, Article 2, Paragraph 4 of the United Nations Charter. The United Nations Charter marked a sea change in public international law. I'm going to gloss over a lot of subtleties here, but I think it's fair to say that prior to 1945, international law had little, if anything, to say about whether it was permissible for countries to use force. Resort to arms, resort to force was considered a legitimate tool of statecraft, and the reasons why countries could use force was quite long. Obviously, if they were attacked, they could use force, but they could use force to get debts paid, to avenge insults to the national honor, to respond to attacks on their citizens, to respond to attacks on property owned by their citizens, et cetera, et cetera. The UN Charter, after the horrors of World War II, seeks to put an end to that. And in Article 2.4 says, all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations. This is a fairly categorical rule. There are two exceptions to it in the UN Charter, and then a few others that aren't in the Charter that are argued for, and I'll go through each of those. Important to emphasize that despite American actions in various places around the world since 1945, the United States has professed adherence to Article 2.4. I mean, if nothing else, the United States was the primary author of the UN Charter. The drafting conference took place in San Francisco. If you look at episodes like the Iraqi invasion of Kuwait in 1990, the Russian invasion of first Crimea in 2014, and then the invasion of Ukraine proper in 2022, the United States, as its official position, says these were unlawful acts of aggression in violation of Article 2.4. Whether or not now, there is some debate at the margins about what degree of force is needed to violate Article 2.4, but I think it's fair to say in the Venezuela case, we are nowhere close to those marginal gray areas. It doesn't matter that you don't intend to annex the territory. It doesn't matter that you aren't leaving large numbers of troops in the territory. Venezuela has the sovereign right to keep foreign troops off of its territory if it chooses to do so. Here I want to quote from this interesting OLC memo, which, as I said, does not purport to answer the question of whether this action is in violation of international law. Instead, it's answering the question of whether there were any US law problems. But they do talk about international law. And the memo says, to be clear, we have not reached the definitive conclusion about how international law would apply to absolute resolve. That's the name of the operation. Then there's some redacted part. But it says, there are arguments that Maduro's refusal to cede power following the most recent elections demonstrates that the true representatives of the Venezuelan people is unable to control the threat Maduro poses to the United States and its allies in the region. So they kind of hint around what may be an argument, but don't really give us an argument. Well, let's talk about these possible exceptions. The first exception to this prohibition is one that just doesn't apply here. It is when the UN Security Council grants authorization for the use of force. Obviously, that didn't happen. Obviously, it won't happen retrospectively because the United States would lose a resolution that it might seek to introduce. So we can dispense with that one. The second is force used in self-defense. And the right to self-defense is set out in Article 51 of the Charter. It's referred to as inherent self-defense. And Article 51 says that nothing shall impair the inherent right of self-defense if an armed attack occurs against a member of the United Nations. And then there's some other language that I don't think really concerns us. What's critical here is that there be an armed attack. Not an insult to the national honor, not a criminal act over which the invading state may have jurisdiction, not that there may be some loose affiliation with criminal gangs that may cause mayhem in the United States, not that a number of years ago, the oil refining capacity, although not the oil itself, was expropriated by the Venezuelan national government. An armed attack. And I don't see anything that approaches an armed attack. There have been a couple of statements by US diplomats to the Security Council that equates the distribution of narcotics within the United States with an attack. They have even mentioned Article 51 in some of these statements. I have to say that this just does not accord with international law at all. There were efforts after the drafting of the UN Charter to expand the conception of armed attack to include other things that were harmful to other countries. Developing countries, for example, wanted to include economic coercion in a definition of an armed attack. That was rejected. The idea really is traditional use of force. There's an additional problem with the argument which Saeed very capably laid out, that the Maduro government is working with Tren de Aragua and other designated narco-terrorist groups to distribute drugs in the United States. And that is demonstrating some sort of connection between those groups and the Venezuelan government, such that under international law, you can attribute the acts of the drug gangs to the Venezuelan government. It's not enough that they may send drugs from Venezuelan territory, or that there may be some kickback scheme by which Maduro and his cronies get some profits from the drug trade. The relevant standard in international law appears in Professor Roth's favorite case decided by the International Court of Justice, the Nicaragua case, which requires direct control by the state over a non-state actor in order to attribute the acts of the non-state actor to the state. And without going into the details of that attribution standard, I've seen no evidence whatsoever, and I suspect there isn't any, that you could make that case. So that is, the self-defense claim. How am I doing on time, by the way? 5 minutes, okay. There is a argument that's related to self-defense, which is hinted at in the OLC memo. And that is the so-called unable or unwilling argument. And I read this passage where the OLC says that Maduro's refusal to cede power following the most recent elections demonstrate that the true representative of the Venezuelan people is unable to control the threat Maduro poses to the United States. This is an allusion to an argument that the United States used justifying strikes on ISIS forces operating in Syria during the Syrian civil war. And the argument was that ISIS was using Syria as a staging area to attack America's ally, Iraq, and that the Syrian government, because it could not control those areas of Syria where ISIS was operating, was not able or was not willing to prevent those attacks. And so rather than sit back and have a US ally suffer these attacks, the US argued, international law permitted it to step in and do what the Syrian government should have done on its own territory in its stead. That is a very controversial argument. A lot of states reject unable or unwilling. I should say that it is a variant of the self-defense argument, and to the extent that there hasn't been an armed attack here, as I described before, unable or unwilling goes nowhere because its predicate, an armed attack, simply hasn't existed. But the circumstance that, in Syria simply doesn't apply here. I mean, what OLC seems to be saying is that the person who won the election in Venezuela is unable to stop Maduro, the person who lost the election, from colluding with drug gangs. That has nothing. I don't even understand how that works with unable or unwilling, but they made the argument. Okay. Now we're leaving the UN Charter and a couple of other justifications that, as Saeed said, have been floated around. There seems to be a new one every day, and I'll mention these very quickly. First, President Trump's claim that they took our oil. First, it's not our oil. It's oil under Venezuela. It's their oil. What actually happened was, as Saeed said, there was a nationalization of the oil drilling facilities and infrastructure. At least the American oil companies that were harmed by those nationalizations availed themselves of opportunities for arbitration to resolve those claims. They won all those arbitrations, and much of the awards are uncollected. So we have a process to get American oil companies compensated, but that is in no way a justification for the use of force. If we were in the 19th century and we were still practicing gunboat diplomacy, maybe forces of the United States or Imperial Britain or Imperial France would go into places that nationalize the property of their citizens. But the UN Charter, at least in theory, did away with that area. With that idea. Next argument hinted at is some idea of pro-democratic intervention. As Saeed indicated, there was an election in Venezuela in 2024. The candidate that was most popular, the Nobel Prize winner, Ms. Machado, was disqualified. So Edmundo Gonzalez ran in her stead, and he was seen as very much allied with her. Reports, which you can question, suggest that Mr. Gonzalez actually won the election, but he was not permitted to take office. After President Maduro was rendered back to the United States, of course, neither Mr. Gonzalez nor Ms. Machado was put into office. Instead, Delcy Rodriguez, who was Mr. Maduro's vice president, was put back into office. And so there's a lot of rhetoric in the administration documents about the illegitimacy of the Maduro government. But it's hard to take that seriously if we were not acting on the principle of democratic legitimacy when going in, which would seem to compel putting back into office or putting into office those who purportedly won the election. We haven't done that. And of course, President Maduro was not just an individual. He sat atop an entire party apparatus, which, as Saeed indicated, he inherited from the previous president. And that entire apparatus is still there. So there has not even been regime change, if you conceive of a regime as broader than just one person. I should also say that the whole idea of democratic intervention is quite controversial. It's something Professor Roth and I have written about quite a bit. Finally, after President Trump said that we're going in for the oil, the next day you may have seen that Secretary of State Rubio went on a bunch of TV shows and said, no, actually, this was just a law enforcement operation. And the troops that we sent in were there in support of the law enforcement operation. And it's completely legitimate for us to seek to bring a fugitive from justice back to the United States. And as Saeed indicated, President Maduro had in fact been indicted in New York in 2020. There was a superseding indictment that was filed after that. I don't understand how this is an international law argument at all. There's no law enforcement exception to Article 2.4. The normal process by which countries acquire fugitives from justice who are wanted in their own country is to make an extradition request through an extradition treaty. There is an extradition treaty between Venezuela and the United States, but rather interestingly, it does not cover the drug offenses and weapons offenses that are charged in the New York indictment. Plus, the extradition treaty also says that neither country is obligated to render its own nationals. So one suspects that even if there was a request under this treaty, which I don't think there was, it wouldn't have been honored. But that's the way you do it. You don't invade other countries and hope that international law will support you. Now, I guess maybe the last thing to say, because it may be occurring to you, is, well, what about Adolf Eichmann? You might know that Adolf Eichmann, one of the architects of the final solution, was grabbed in Argentina by Israeli forces in the early 1960s, brought back to Jerusalem, where he stood trial for his role in the Holocaust, and that was memorialized in Hannah Arendt's famous Eichmann in Jerusalem. We could have a long debate about the lawfulness of that action or not. There are a lot of international law scholars who say that that simply was not a lawful action. But I think it's important to understand that much of that argumentation relies on what Eichmann actually did. He participated in the most egregious atrocity crimes that international law has codified: genocide, etc. If there is any sort of exception for rendering somebody, it is, and this is, I think, the view of most scholars, it's limited to those sorts of crimes. Running drugs and running guns doesn't even come close. So that precedent, I don't think, really supports what the United States did. Thank you.
Thank you so much, Greg, for really a wonderful presentation on the public international law aspects of it. We'll now hear from Professor Brad Roth.
Thank you, Saeed, and thank you, Greg, for setting the table for a discussion of what happens when international law comes to the United States. And the answer turns out to be a fairly depressing one, and I'll probably be depressing you all. But there are a whole series of things to say about the way in which international law interacts with the domestic legal order. And the first thing to note is people often express frustration about international law and even ask the question, is it really law? And it's because people's model of real law is this old, sort of 17th to 19th century conception of law as a command backed by a threat. And if you don't have that, if you don't have the kind of force being put behind the law, then is it really law? Well, I want to argue that public law in the United States is really very similar to international law in that all it has going for it is the sense of legitimacy, that public law is about law that governs the people who exercise power, it's law who governs the people who have the guns and the money. And that all that domestic law has to constrain the exercise of power is a kind of shared consciousness among officials and citizens of what the limits are of the exercise of power. And that was manifest in a brilliant way a couple of generations ago in the ouster of Richard Nixon. And I was in this room about a year and a half ago doing an event about the history of the ouster of Richard Nixon and his violations of public law. I think that that in fact the Nixon experience gave rise to a resurgence of interest in constraints and gave rise to legislative and judicial action to try to cabin exercise of power by the executive. And I would argue that that's what we need again. The question of whether action is lawful is actually a much more complicated question than meets the eye. First of all, because we have this problem that there are two different legal orders at issue here. Well, it's actually, there are more than two because there's the Venezuelan legal order. We won't get to that. But the international order and the domestic order are two separate orders. They intersect in certain ways. But they are self-sufficient in the sense of determining what is lawful within their own purview, which can overlap. And so the same act can be lawful and unlawful simultaneously. And that's a difficult thing to get one's mind around. There is not an international supremacy clause. We often think about the greater as subsuming the lesser, that the federal government somehow subsumes state governments in our system, which is largely true. Based on the idea that if states commit acts that violate the federal constitution, those acts are null and void, and they're incapable of creating legal facts that would be acknowledged by the courts in either system. That's not the way things work in the international order. Contrary domestic law is not a defense to a breach of international legal obligation, but the breach of international legal obligation doesn't nullify the sovereign authority to create legal facts. At least as a general matter. It could in certain very specialized circumstances. And this is true both with respect to Venezuela's breaches of international legal obligation and America's breaches. So we have to think about what's lawful within the scope of particular legal orders. Then we have the problem of, well, what does it mean actually to say that something is a violation of law in the United States? One of the problems in U.S. foreign relations law is that we really have very little judicial precedent on crucial questions. And in fact, there is so much that we don't know about fundamental aspects of our law with respect to foreign relations. You might, if you take a look at the Constitution, you might see something about treaties, and you might think that, well, the way we get into a treaty is what's specified by Article 2 of the Constitution. Well, actually, there are lots of other ways that we get into treaties on an international plane that are not within Article 2 of the Constitution, and they're still treaties for international law purposes. And it tells, and the text of the Constitution tells us how to get into a treaty. It doesn't tell us how to get out of one. And I can go on and on with all the things that we should know looking at the Constitution that we actually don't, and that where we really get very little guidance from courts. And we get very little guidance from courts specifically in cases of foreign relations because of judicial deference and abstention. That the courts want to stay out of issues of foreign relations. They concoct various kinds of doctrines to dodge questions. They create doctrines about standing and questions about ripeness and questions about mootness. So if it's a hypothetical question, it can't be answered because it's not ripe. If it's already happened, then it's overripe. It seems like it never goes through the golden moment of justiciability from ripeness to overripeness. And then there's also something called the political questions doctrine, which is a huge set of dodges as well. And so partly for that reason, we get really very little determinacy from case law. There's a famous statement by a foreign relations law scholar who speaks of the Constitution as an invitation to struggle over the direction of foreign relations. And so what happens, the U.S. foreign relations law is largely created by the push and pull of the different branches of government over these matters and the development of a kind of customary practice over time. And the problem is that if the executive keeps pushing the envelope, if the executive asserts itself and Congress doesn't push back and acquiesces, then effectively the executive has changed U.S. foreign relations law, and particularly in circumstances where the courts are not going to adjudicate the question. How do we know whether it's lawful? We're going to anticipate what the current Supreme Court majority thinks, but we're largely reading the tea leaves. And in the absence of that, we have this Office of Legal Counsel that Professor Fox referred to in the Justice Department, which sets the position of the executive branch of government on questions of law that pertain to it. And in many circumstances, the last word effectively is going to be the Office of Legal Counsel, simply because there are not going to be avenues for judicial challenge to what it is the executive does. And so we have a situation of incredible flux. We have these memos. Some of these memos are actually secret memos. Some of the memos, as you see, have redactions, so we don't even know what they're talking about. And this becomes the basis upon which public officials rely for determining whether or not their actions are lawful. And then if they get bad advice from the Office of Legal Counsel and they happen to get prosecuted, they could be actually able to trot out these memos and say, well, I was following the best legal advice as to what I was doing. And we can go into a whole series of circumstances where that sort of thing has occurred. So the other thing, though, is we could say that irrespective of existing precedent and irrespective of certain kinds of opinions, that there's a claim to be made about constitutionality that withstands the authority or absence thereof. And a perfect example of this, as I point out in the outline, is the case of Korematsu versus United States, because we in the wake of December 7th, 1941, the United States interns 110,000 people of Japanese extraction, over 70,000 of whom are US citizens. And they do so in ways that would seem to blatantly violate the Equal Protection Clause. They mark people out on the basis of their heritage. And the Supreme Court holds by a majority that this actually is consistent with the Equal Protection Clause of the Constitution. There are ringing dissents from dissenting justices, but the question is resolved in a certain sense in favor of the constitutionality of this act. Now, everybody knows, looking back on this, that this is a discredited precedent, that in fact the internment was a violation of the Equal Protection Clause. The Supreme Court has since admitted this. An apology was given in the 1980s to Mr. Korematsu and to Japanese Americans who were interned. So we understand that what we call the Constitution is something that has some sort of existence that goes beyond what any particular legal authority at any particular time might say about it. But it's up to us to fight for that. And so far, the situation has been rather bleak because of a kind of systematic capitulation. So I want to talk about two particular areas. One has to do with international law in US law, and the other has to do with the war powers, which are a domestic question. So international law in US courts, this is an area of great peculiarity here in terms of jurisprudence, because international law becomes engaged in the in the domestic legal order, but on the terms of domestic law. The domestic law determines under what circumstances the international legal norm has legal effect in the domestic courts. And this is highly qualified in our system. We have a number of statements that would appear to represent the idea that we are fully incorporating international law into our domestic law. And part of that is actually in the Constitution of the United States. Article 6 speaks of treaties as part of the supreme law of the land. Professor Fox and I, along with Professor Dubinsky here, co-edited a book less than a decade ago called Supreme Law of the Land, and there's a question mark. The main point of the book is not really. And a key aspect of this is a doctrine of what's called non-self-executing treaties. So some treaties have direct effect in US law, but there's a whole class of treaties really that don't. And sometimes it's difficult to tell whether a treaty is self-executing or non-self-executing, and this is itself an object of study. But basically the rule is that there are treaties that are multilateral treaties that have large numbers of states that join on to these treaties, and they're treaties that are attempting to solve a global problem, and they represent what I call international public order norms. And those treaties really are systematically understood to be non-self-executing in our system. Sometimes they're expressly so. Human rights treaties always have a declaration attached to the instrument of ratification that says that this treaty is non-self-executing. But even where that practice was not engaged in the past, it's been kind of read back into the practice. And so a non-self-executing treaty is not going to be a rule of decision in courts. And there is a real question as to, as I'll get to in a second, whether even it counts as part of the law of the land in any respect. There's also then the other big component of international law is customary international law, which are systematic practices in the international system where states have, by their behavior, manifested an understanding that there is a particular norm that guides their conduct and to which they are bound. So this is a combination of what we call in the trade state practice and opinio juris. And so there is customary international law in a wide range of areas. In fact, treaties are predicated on customary international law because it's like having contract law be the basis of contracts. We have the customary law of treaties that were initially the foundation of treaties. So we have customary international law, and we have a Supreme Court opinion from 1900, which I always refer to as containing the first lie we ever tell our students in classes about international law, because the case called Paquete Habana has this language: international law is part of our law, which is just great, except that there's qualifying language even there, and that qualifying language has been interpreted in ways that probably the court in 1900 did not anticipate. And the key language that you need to remember is controlling executive act. It's actually controlling executive or legislative act. A statute overcomes a norm of customary international law for domestic purposes, but so does an act of the president or an act of a cabinet level official. At least that's as it's been interpreted by U.S. federal courts. It's never gotten to the Supreme Court, but the U.S. Court of Appeals has made that determination, and it appears over and over again in Office of Legal Counsel memoranda. So there is the subordination of international law generally. More particularly, there are all kinds of ways relevant to this particular circumstance where the law is subordinated. So Professor Fox was talking about the fact that that President Maduro was, taken in a smash and grab here. This was not an extradition. This was an action which violated the territorial integrity of Venezuela. You cannot use law enforcement of your own state in the territory of a foreign state without that state's consent. The problem here is a principle known as male captus bene detentus, which is to say, just because we seized the person wrongly and hold the person wrongly, seize the person wrongly doesn't mean that we have to give the person back. And so this has actually echoes in international law. The Eichmann case, as Professor Fox referred to, is an instance of male captus bene detentus. Everybody understood that Israel violated Argentina's territorial integrity when they snatched Eichmann. Well, one thing to note about that was that Eichmann was not an Argentinian citizen, nor was he an Argentinian asylee. He was living under an assumed name with the kind of connivance of Argentinian officials, but they didn't acknowledge his presence there. And the whole thing was an embarrassment. And eventually, Israel pretended to apologize, and Argentina pretended to accept the apology. And it all moved off from there. And Eichmann was prosecuted in Israel. There are lots of cases like this. A lot of the time, we're talking about fugitives from justice who are fleeing to a country not their own and not actually getting asylum in those countries. And it's hard to say that they're entitled to the protection of the places from which they were snatched. This is different here, but the problem is that the United States does not acknowledge in its law any such distinction. We do have an exception where there's a violation of an extradition treaty. And you might think, well, we have a treaty with Venezuela that regularizes the rendering of suspects across borders. And so clearly we should have used the treaty. And since we didn't use the treaty, or this was an exception to the treaty, then we're violating the treaty by obtaining custody over Maduro in this way. Bizarrely, the United States Supreme Court has dealt with just such an issue and has taken the position in a way that is, I think, wrong, but more clever than it sounds, that the kidnapping of someone is not a violation of the extradition treaty because extradition is one thing and kidnapping is something else. And the notion is that rather than actually abusing the mechanisms of the extradition treaty, which would be self-executing and would contradict male captus bene detentus, that this is just a kind of extrinsic violation of international law. It violates the territorial rights of the state that we're kidnapping the person from. That state may have some recourse against the United States. But whatever the remedy is, it's not the remedy of being sent back. And so that is the way that the United States has handled this in a case called United States versus Alvarez Machain, who was a Mexican who was grabbed in this way. He was interestingly acquitted in U.S. courts and then sued the United States government, and that failed miserably as well. Aliens abroad are, generally speaking, not thought to have constitutional rights against the United States. It's not obvious to me that that is completely true, but there are a couple of precedents that point in that direction, and they've been seized upon by the U.S. government. And there's no clear contradiction of this. So there's cases of Eisentrager, Johnson versus Eisentrager after World War II, and United States versus Verdugo Urquidez, combined to present the impression, at least, that there is no constitutional right that can be asserted by an alien abroad against an action of the United States government. I think it's wrong, and I think probably if the right case came up, that might be contradicted. But for now, there's nothing that really undermines it, including even the assertion that there's habeas corpus rights with respect to a particular territory abroad. The procedure of that is different from the substance of that, and it's never been adjudicated what the substantive right is in a territory, even where habeas corpus applies. The Federal Tort Claims Act might be seen as a basis for suing the United States government, but suing the United States government doesn't work where the action has occurred abroad. And so there's not any recourse when you've been snatched in this way. Another issue is immunity. Maduro is president of Venezuela under the terms of the effective government of Venezuela. Delcy Rodriguez is acting president at the moment. But you have a situation in which the head of state of a foreign country has been seized. This is in violation of principles of immunity. And there is a controversy over whether Maduro is in fact the president of Venezuela from a standpoint of international law. There are a substantial number of countries that do not recognize him as having that capacity. But the general rule, which is not contradicted by any overwhelming consensus of the international system, is that he does have that status. The problem is that even if he is the president of Venezuela from the standpoint of the international system, he is not immune in U.S. courts because the question of whether he holds that position and therefore holds that immunity is a question that's been conferred to the State Department. The State Department will issue a statement of interest on this question, and the court will automatically, in this case, defer to this without looking behind it. So he will be stripped of immunity on that basis. There's another kind of immunity about whether the act was within the scope, carried out within the scope of his official capacity. There, the issue in international law is pretty close because it's not clear whether you would characterize the acts alleged as being within the scope of official capacity or just some further criminal act that he's otherwise undertaken. But that is not going to be an issue in any event in our courts because, again, the statement of interest of the State Department, although not as completely conclusive with respect to this conduct immunity, nonetheless will be deferred to by the court, certainly. And so regardless of what immunities he has as a matter of international law, he's not going to have any real opportunity to make the claim in U.S. courts. Finally, with respect to international law, the question of the Article 2, Paragraph 4 of the UN Charter referred to by Professor Fox it would seem to, if nothing else, give rise to an abstract constitutional obligation on the part of the executive to take care that the law be faithfully executed. The problem here is that if you look carefully at the language of the one case that really addresses this question, the case of Medellin versus Texas in 2008, it's very difficult to draw that conclusion. The Supreme Court, opinion written by Chief Justice Roberts, really contradicts the idea that a non-self-executing treaty is law at all in the U.S. system. And even though many of us think that's completely wrong, I think it's hard to get much traction for that in the face of the specific language. Finally, I just want to say something about the effort to control the war power. There have been long efforts on the part of advocates of congressional authority to try to seize back authority from the executive. There's the declare war clause, but we don't declare war anymore. That's an obsolete idea. And there's been no war declared since World War II. The United States has intervened militarily, literally hundreds of times, and there have only been declarations of war in 5 different wars across our history. And increasingly, the executive makes assertions about its capacity to do this. The War Powers Resolution of 1973 was an effort to keep the United States from sliding into war without proper deliberation, without proper congressional participation. That effort, I think, has to be said to have been a failure. There are a number of different constraints, all of which have been undermined. I won't take the time now to try to elaborate each of them. But although people won't admit that the War Powers Resolution is a dead letter, the reality is that Congress may declare war, but the president makes war. And unless we seize back that authority from the executive, we're kind of stuck with where we are. So thank you.
Thanks so much, Brad. Well, that brings us to time for some questions. I see Professor Pearson has his hand up first, so I'm going to go ahead and find one of these that works. Oh, is it? Okay. Oh, thank you. Okay. Great. Thank you.
My colleagues. But thank you. Thank you so much for this enlightening presentation by all 3 panelists. And you're dealing with law, and I want to make a mention of the term law and order, because we hear that at TV shows and other things. But to me, order is also important. And I think I would argue that what's happened here under this administration's actions is an erosion of order as well as law in the international scene. And by that, what I mean is that, for instance, in various ways, the administration is hypocritical on what it does. Just to get to it in a second, the issue of tariffs normally would have been undertaken with something called the World Trade Organization, I would have thought, because we were instrumental in founding such an organization to handle disputes about economic relationships. But we didn't even mention the World Trade Organization in dealing with tariffs. And if you move on to conflicts, there's a similar expectation, I would argue, under the UN, which is that conflicts are handled initially by regional organizations. And in this case, we have one. It's called the Organization of American States, the OAS. And again, no reference to or mention of the OAS, which should have taken up such a dispute over whether drugs are or not being trafficked and terrorism is practiced or not, but we didn't even refer to that in acting the way we wanted to. So as well on hypocrisy, we have the administration arguing that Maduro is an illegitimate leader who didn't give up power, but we back a leader who lost power that we like better in a neighboring country of Brazil. His name is Bolsonaro, and him we back, even though it's very questionable whether he won anything. And in his behavior acted much like January 6th here in this country. But in Maduro, who's a leftist, so-called, we oppose staunchly, even though he is in power. That said, also, I would add to Saeed's comments about the history, which is that this is not the first time Trump has tried to overthrow Maduro or has acted against Maduro. He did so in his first administration by attempting to organize the Venezuelan army, I believe, to overthrow Maduro. CIA probably involved in that too, and that was a failure, but it indicates a long-term opposition to that leader. And finally, on the question of intervention and when it's legal or not legal, I would mention, of course, the U.S. pursuit of and elimination of Osama bin Laden in the territory of Pakistan, where arguably Pakistan knew it was going to happen, but had needed to have deniability. And so it said it didn't know when we went after bin Laden in that territory and finally got him. And maybe we would have brought him back, but evidently the incursion resulted in simply killing him. So all kinds of shenanigans have gone on in the case of bin Laden with much greater, I think, legitimacy. But in this case, much disturbing erosion of international order.
Would either of you like to respond to that?
Just very briefly, Fred, I think you're right to identify an overlap between international law and order in the conception of the proponents of the post-World War II legal order that you have been describing. I don't think that's how Trump perceives order. I think Trump perceives order as something approaching 19th century spheres of influence, where regional powers take care of their own area. And the fact that there's armed conflict doesn't mean that there's disorder. It means that there is an opportunity for the regional power to assert itself, to get its interests effectuated. And there's certainly no disorder if there is an armed conflict in somebody else's region of influence. That's their problem, not ours. If there is spillover effects and it is our problem, then we'll negotiate. You know, Trump will sit down with Putin, they'll work something out. But the idea that you need some neutral set of rules, a neutral set of institutions to adjudicate this and kind of put everybody on a level playing field, come on, that's so 1990s.
Yeah, my name is Cyril Vidmar. I'm here visiting at Wayne, but otherwise professor of international law at Maastricht University in the Netherlands. So thank you to all three panelists for this excellent discussion, for these excellent presentations. I will start with Brad, with your arguments. I think you mentioned that a few years ago, the United States and a few other states de-recognized Maduro as the president of Venezuela, and at the time recognized Juan Guaido as president of Venezuela. And you also mentioned that it would be very important for the proceedings in U.S. courts what the position of U.S. government is on who is the right authority, who is the government in Venezuela. But I'm now wondering, do you know who the United States government actually thinks was the president of Venezuela on the 3rd of January? Was it Guaido, was it Gonzalez, or was somebody else? And if I may add to that, so you mentioned that there is also some other countries that did the same, but I think actually very few countries de-recognized Maduro and explicitly recognized Guaido at the time, because this recognition texts were phrased in such a way that in many instances they were not recognition texts. For example, the Netherlands, if I remember correctly, said in that text, we recognize Juan Guaido as a legitimate representative of the people of Venezuela, which is not the same as saying we recognize Juan Guaido as the government or the president of Venezuela. So that was merely a political statement, not a recognition text. So, and I think it was the United States and the United Kingdom that did explicitly de-recognize and then recognize somebody else, but not very many other states. And what do you also think would this de-recognition, when it was de-recognition, what consequences would that have for international law and for the status of Maduro on the 3rd of January?
Well, Professor Vidmar asked me this question because he and I both write about these kinds of issues and could have a conversation about this for hours. What I'll say in response, just to give people some sense of what's going on here, is you had a moment in which, so Maduro is initially elected in the wake of Chavez's death. He became president in 2013 provisionally after Chavez died, ascending from vice president, but then he had to run in the election. He was elected in a pretty clean election, I think, in 2013. In 2018, though, there was serious question about the conditions for the election. Most of the opposition boycotted the election, and he was elected in terms of the vote count, but in a way that was not regarded as legitimate. Meanwhile, there was a 2/3 majority of the National Assembly which supported the opposition, and the National Assembly president, Juan Guaido, was established by the National Assembly as being provisionally the president of Venezuela on the ground that constitutionally there was a vacancy in the presidency because Maduro had not been properly been elected. So Maduro then, so during that period, there were states that regarded Guaido as the head of state. And the Organization of American States actually seated the representative of the Guaido government, not the Maduro government, unlike the United Nations, where the credentials remained in the hands of the Maduro government. There were also some places around the world, as you point out, where the Guaido government was officially elected, and that had real consequences for the ownership, particularly of Venezuelan state property, which was conferred upon people who were authorized by the Guaido government. In any event, the Guaido government goes out of business in 2022. There is no further effort at that point. There's an expiry of that effort. And then after the 2024 election, even though it's much clearer actually that there's an alternative person who seems to have been elected, there's very good evidence that he was elected with over 2/3 of the vote. There's no effort to create a government in exile. Gonzalez flees the country, as does Maria Corina Machado eventually, who is the kind of real figure in the opposition. So there's no alternative government for anybody to recognize at this point. There are countries that continue to assert both politically that Maduro is not the president, but also continue to deny Venezuela the representation of the Maduro government. The OAS has left the representation vacant at the moment. So that's kind of where things stand. And I would argue, as I think you would as well, that from the standpoint of international law, by far the better position is the reversion to the basic doctrine of effective control through internal processes, absent any kind of other structure that could genuinely compete for this. There are issues that arise in certain cases where there are governments not in effective control that have been denied their electoral mandate by military authorities. But the requisites, even for that proposed alternative, are not really in place here.
Question here.
This is on. Okay. So I have a question for clarity. We were talking about self-executing laws. I admit I have no idea what that means, and I'm wondering. Well, I'm wondering if it is applicable to Article 2.4. Is it applicable to Article 2.4? Yes. Okay. So then, would Article 2.4 be self-executing or not? I guess I should say everything, and then so that was my first question, is like for clarification's sake, and then what sort of would be the implications of that, and then so our politics bear importantly on the law, and I'm sort of on track with Professor Pearson here, because while the law, of course, is significant, necessary, in fact, our politics do color the law. And we're in the middle of an administration that is vehemently anti-internationalist. And to that extent, I think goes a long ways to explaining why we have this memo that is basically just shrugging and not really caring about international law. And then we have our domestic laws, as you rightly pointed out, Professor Roth, that don't seem to provide any substantial support for international law within our domestic systems. So then I guess my question is, as citizens of a country that seems to be hurtling towards a really dire situation that's putting us all at risk, what recourse do we have legally, if anything at all? I'm also thinking about although it doesn't bear directly on our conversation here, an interview I was listening to our Detroit City Council member on WDET this morning, where she's trying desperately to find ways of controlling ICE within Detroit, and trying to find legal sort of grounds for that. There is a lot of consensus out there with respect to the increasing dangers towards Americans, broadly construed, that is a direct consequence of this administration's policies and actions. So what can we do?
Well, that's a bigger question than I can hope to answer at this point. But what I'll say is that one of the problems that we've had has been a kind of systematic disrespect for international legal standards within our domestic system that's really been bipartisan over time, and particularly with respect to questions of peace and security. So Article 2, Paragraph 4 of the UN Charter, which is the pillar of the international system, has been in many ways overtly disparaged, even by people who you think would not disparage it, but people who have been oppositional to certain U.S. policies have nonetheless wanted to reassure us all that the United States does not need permission slips for using force abroad, and that's the no permission slips line was one used by John Kerry in 2004, and it was used by Barack Obama's people in 2008. So there is this general disrespect. And it manifests itself in attitudes toward international treaties, again, that has been bipartisan. And when the United States has, for example, signed on to international human rights treaties, it has done so subject to a raft of what are called RUDs, reservations, understandings, and declarations. And the first declaration is always that the treaty is non-self-executing, but it's even beyond this because we accept from every obligation that we think might actually compel us to change what we do domestically. And we also try to disable the Congress from being able to pass implementing legislation that would overcome contrary state law in favor of the treaty norm. And so we really have a system that has insulated itself from international norms and have generally just sort of allowed the executive branch of government to take on a kind of power in this country that would seem to violate fundamental conceptions of separation of powers and individual rights.
Thanks, Brad. If I could add something on to your question and then something in regard to Yuri's question. How to constrain the executive branch from using force is a very difficult one. As Brad indicated, we don't declare war anymore. That's the sole portion of the Constitution that seems to give Congress, an on-off switch. I mean, I think Congress, it may be the only body that has the capacity to rein in, what you might see as executive overreach. The best example is the so-called war on terror. There were 2 initial authorizations for the use of military force passed by Congress in the wake of 9/11. And those, I think it's fair to say, to this day, are used by the executive branch to justify the use of force against, affiliated groups to Al-Qaeda 25 years after, the events that gave rise to the resolution. And Congress is terrified to modify or repeal those AUMFs. And Congress needs to get some backbone. And they need to repeal them, and they need to make clear that there are limitations. There are bills that are introduced, I think have been introduced by Democrats in the Senate, that would deny funds for the physical occupation of Venezuela. The executive branch would argue that those are unconstitutional. The courts may not adjudicate claims about that for all the reasons that Professor Roth indicated. But that's the only place it's gonna happen. I should also add that things are really bad now. But Professor Roth is absolutely right that this is something that's happened over time. So kind of this OLC memo that they released yesterday says international law does not restrict the president as a matter of domestic law. That is a quote from an OLC memo from 2002. It's then followed by citations to OLC memos from 1997 and 1989. This is a longstanding position of the executive branch under administrations from both parties. Yuri, your really interesting question about, who do we think, if we don't think Maduro is the legitimate president or was the legitimate president of Venezuela, who do we think was or is? I have no idea. I don't think, if we're being honest here, I'm not sure Donald Trump really is deeply invested in the idea of democratic legitimacy. But, it's conceivable that this issue could come up when, as Professor Roth indicated, Maduro files a motion to dismiss the indictment based on head of state immunity, and that would have to be a conduct immunity. And then there would be this suggestion of immunity or statement of interest from the State Department that would say something like, we didn't recognize Maduro, and it would be contrary, it would deeply intrude upon the foreign policy interests of the United States for this court to consider dismissing the indictment based on head of state immunity. The court might just say, that's it. All we will look at is the statement on its face. We won't go behind the reasoning. That's the end of the matter. I suspect if you're laying odds, that's what would happen. But it's conceivable that the court could ask questions. Like your question, well, if you don't think Maduro is legitimate, who is legitimate? What's the basis upon which you're making this determination? If it's not effective control, which he had, is it who won the election? And if that's true, why isn't that person running Venezuela? And have you asked that person whether they approve of or disapprove of immunity for Maduro? Because a government can always waive immunity of one of its officials. So I wouldn't, get your hopes up that that sort of issue would make it very far in Maduro's criminal prosecution, but it might. His lawyers, and by the way, he has very good lawyers, they will certainly make the argument.
I think we have time for just this last question, so why don't you go ahead?
I want to. Hello. Oh, I want to quick apologize to Professor Roth, Professor Fox, and Professor Sachi for taking it even further. But historically, the UN or international law has shown that its weakness is in its lack of enforcement. But there are arguments that says the UN, specifically after World War II, and international law as a whole, is the colonial institution that firstly serves the imperial interest first and protects the world peace only when convenient. And so I'm saying, what opportunity do we have with this knowledge that on one hand, international law review its weaknesses in the lack of enforcement, but on the other hand, that prove that it functions as it's intended to be, to serve the imperial interest first, and then protects world peace only in convenience? What opportunity do we have?
Well, what I'll say about this is just that if you look at the UN Charter and the founding moment of 1945, it's easy to see this in colonialist terms. The United States Constitution, famously makes no reference to slavery. It just has all of these clauses that perpetuate slavery by another name, or talks about the importation of persons and so forth. You could kind of tell people's guilty conscience by their failure to refer to these things. So too, the UN Charter fails to refer to colonialism as such. It talks about things like non-self-governing territories. But what happens in the years immediately after the charter is a whole wave of decolonizations and the emergence of a whole non-aligned bloc in the international system, which is the reason why when people use the word third world in different ways, the origins of the idea of a third world was in terms of the way in which the international order was divided between the United States and its allies, the Soviet Union and its allies, and the global South as a bloc, organized in organizations called the Non-Aligned Movement and the Group of 77. Group of 77 actually ended up having way more than 77 members. And so the nature of international law, peace, and security really was transformed during this period, because the United States and its allies and the Soviet Union and its allies, in order to maintain legitimacy in places where it wanted it, had to make certain kinds of fundamental concessions, particularly to the principle of non-intervention. They often, of course, honored it in the breach. But the normative structure was filled with fundamental concessions to the decolonized states and to the global South generally, which really set the tone for a lot of fundamental peace and security norms. It failed to overturn fundamental norms about international economic law. There was an effort, so-called the New International Economic Order in the 1970s. It was something called the Charter of the Rights and the Economic Rights and Duties of States, which had overwhelming support, except from all the states that had multinational corporations that were plundering the global South. That was a failure, and so colonialism in new forms could be seen as operating there. But in terms of peace and security norms, actually the global South has had a remarkable amount of success in affecting those, and also in some cases in actually affecting action, for example, against South Africa or against Rhodesia, and the non-recognition of the Bantustans and the liberation of Namibia. These things were very much affected by the United Nations organization and by how international law operated in that era. I don't know if Professor Fox wants to say more.
Yeah, I guess I completely agree with Professor Roth. And, you know, I think the fundamental question that you pose, you know, may stem from an aspiration that the UN Charter certainly sets, that the principles of international law and of state equality that it describes can, in some fundamental way, undermine the international power structures that exist, including colonialism, including economic domination. I'm not sure it surprises anybody that, in fact, that hasn't come about. That, you know, economic power structures continue not completely as they were, but you know, they have not been fundamentally dislodged. But that you know, kind of inability to achieve the maximum goal, I think, doesn't invalidate the major contributions to the developing world that the post-war international order provides. You know, the most comprehensive description of law on the use of force came in a case which I alluded to before, that Nicaragua brought against the United States. You can't imagine a more fundamental imbalance of power between the Sandinista government in Nicaragua on the one hand and the Reagan administration in the United States on the other. And because of the UN system and the fact that the United States had accepted the jurisdiction of the International Court, which it quickly renounced after the Nicaragua case, Nicaragua was able to sue the United States and get a court judgment declaring that its myriad actions to overthrow the Sandinista government were unlawful. And that has changed the bar. That has clarified law. It becomes you know, the lingua franca of diplomacy, the way states talk to each other. International discussions about the use of force begin with principles that are articulated in the Charter, in the Nicaragua case, in the General Assembly's definition of aggression, in the statute of the International Criminal Court, which now includes the crime of aggression. And if you are a developing state that finds yourself vulnerable, those are quite useful tools. And if you look at the aspirations of the liberation movements that you know, we're trying to you know, achieve statehood in former colonies, their greatest aspiration was to achieve full sovereign equality, so they could use all these tools that were available in the UN system. Again, those tools may not achieve an ideal end, but you know, are we better off for them being there than not being there? I hope so. There's some
Thank you, Greg, for ending today's presentations on an optimistic note, as well as to hopefully provide you with clarity, clarification, corrective, as well as context to the complexities regarding Venezuela, showing you that there is the architecture of many different levels of law, which should provide you with a comfort that we then do not have to rely on one man's morality in order to then have the checks and balances that are required for the international system and the rule of law in order to remain. I want to thank my esteemed colleagues, Professor Brad Roth, Professor Gregory Fox. Please join me in a round of applause for their presentations. And also thank you for making this event the reason why we like to have events like this. Your participation, your attendance, and hopefully your greater understanding to what is happening in the world around us, particularly as it is a function of citizenship. Your very presence here is an act of citizenship. And so from the Center for the Study of Citizenship, I thank you for that. Please stay tuned. This particular presentation has been recorded, and I have been told that it will be then available, I think, on YouTube. Okay, Professor Roth will be taking care of that. So please let others know about today's event. And from the Center for the Study of Citizenship, given the enthusiasm for this, it gives me then optimism and also now commitment to have future events. I suspect probably next month, because I'd like to do this on a monthly basis, we may be speaking about Iran. Given the fact that German troops are heading to Greenland, that might be another topic of discussion. And I'm sure April being, as T.S. Eliot said, the cruelest month, we probably will have an apt topic for then as well. Again, thank you for being here. Please drive carefully. The conditions are not very pleasant out there. But again, thank you very much for your support and coming today. Thank you.